Okay, good morning, everyone. Well, if morning is applicable. Welcome to today's second session on the legal implications of artificial intelligence. My name, as you can see, is Tina van der Linden. I am an assistant professor in law, ethics and technology at the Vrije Universiteit Amsterdam. And I'm a board member of the Dutch Association for Computers and Law. I shall be your moderator for this session. Before introducing our panelists, if you as audience have a question or a comment, please use the Q&A button on the lower right-hand side of your screen. I will be able to see your input and pass it on to the panelists. Please do contribute if you have something to say. Okay, the panelists for this session. First, we have Professor Dr. Jan Bernd Noorderman from Humboldt University in Berlin and also from the Noorderman law firm. Second, we have Professor Ryan Abbott, who has a dual degree in medicine and law, so MD, GD, medical juris doctor. He is a professor of law and health sciences at the University of Surrey. And Ryan is currently in Los Angeles in the Pacific time zone, which means that for him, it is now 2:30 in the night. So thanks a lot, Ryan, for being with us. Last but not least, we have Mr. Alessandro Montelero, who is an associate professor of private law and technology at the Polytechnic University of Turin, and also an AI expert at the Council of Europe. We will start with a presentation on copyright protection for AI-generated works by Professor Noorderman. So please, Jan Bernd, the floor is yours.
Yes, thank you so much, Tina, for the nice and warm introduction. And I'm very happy and honored to be here and present on copyright protection of AI works. Let me share my screen so that you can see what I will be talking about. Yeah, so copyright protection of AI-generated works is what you will hear from me today. And of course, you know, as a German, I've brought you a table of content. You know, when one of the last times I presented in London, the co-speaker said to me when I started off with the table of content and the program, he said, well, Jan, that's very German to start with a table of content. I, as a British speaker, would always start with a joke. So, you know, that's the German way we do it now in this little presentation to give you the table of content. So we will first look at AI-generated works. I will tell you something about the European approach to copyright law, and maybe if you're not from Europe or not from the EU, you will want to compare your home jurisdiction with the EU approach. In particular, we will look at genuine copyright protection for AI-generated works, or at least the protection via neighboring rights, sometimes also called related rights. And then I will also take a little international perspective, go outside the EU, look at the AIPPI resolution from 2019, the WIPO conversation on IP and AI, and also at some statements from the US Copyright Office, which are also interesting, I think. So what's the European approach, the EU approach to copyright protection of AI-generated works? Generally, you can say that a work, in order to be copyright protected, needs to be original. Yeah, that's the key word, original, in the sense that they are the author's own intellectual creations. This is, standing case law of the CJU as the highest EU court to interpret EU copyright law. This requirement for copyright protection that it needs to be an author's own intellectual creation was, for example, set out in the two recent decisions, Levola Smilde Foods, which is sometimes also called the Dutch cheese case, because it was about copyright protection for the taste of cheese, which was then denied, of course, as you all know, by the CJU. You also see this requirement of author's own intellectual creation in the Brompton bicycle case, which was about copyright protection of a bicycle as possible applied art. You can take from that, I think, and that's the very, very prevailing opinion in the EU, that the author of a copyright protected work may only be a natural person. Author's own intellectual creation, I think, assumes a natural person as an author. And if you look further into CJU case law, you will, for example, come to the Luxan van der Let decision of the CJU, which is just almost 10 years old already. But here the CJU also said that a film author can only be a natural person, i.e. in this case, the director, and it cannot be the film producer, for example. Also, there are quite a few national copyright acts in the EU that explicitly say that an author can only be a natural person and not a machine. For example, Section 7 German Copyright Act, and maybe you can also look into your national copyright act if you will find the same in your copyright act. I know that there are quite a few that also specifically say that. So to summarize, the EU copyright regimes rely on human creation for copyright protection. Without a sufficient original human input, no copyright protection is possible. And that, of course, is the starting point for copyright protection of AI-generated works as well. If you look at the different scenarios, where you could find sufficient human input into AI-generated works, it starts, as it's shown here on the slide, it starts with the programming and the training data. Of course, I mean, in order not to misunderstand this, of course, the computer program used to generate the AI work can be copyright protected, as any software can be copyright protected. Also, the training data used to generate the AI work can be copyright protected. You can train, for example, the machine with copyright protected photographs or with copyright protected paintings. So the infrastructure used or the data used to generate the work can be copyright protected, but that does not mean that the work generated is automatically copyright protected, because it is not a sufficient human input into the AI work generated as a result to have a copyright protected software doing the process, or that you have copyright protected training data. So that's not sufficient to make the AI product copyright protected. The process controlling is rather at the core of interest when you want to decide if you copyright protect the AI generated work. If the human creates original elements of the work and AI is limited to executing this created concept, we will find copyright protection of the AI generated work. In this case, and that is also on the slide here, I would say AI is just a tool for the human author. AI is like a brush, yeah, to paint a painting, for example, a camera to make a picture, which is copyright protected. But you can, copyright protection is not excluded because you use a machine, but still the product, the output needs to have a sufficient human input in order to be copyright protected. When you go on and say, well, maybe the selection of AI-generated works may result in copyright protection for the work selected, I can only say, I don't think that this is a reason to give copyright protection to the AI-generated work selected, because copyright protection depends on whether the AI-generated work is original in itself and not the selection process for the AI-generated work. That is not sufficient. There are voices in academia and literature that think that this is sufficient for copyright protection, but I don't think that this is convincing. Let's look at the criteria that, for within the process, whether there is sufficient human input, because as I said, you need sufficient human original input into the process, into the AI generated work. So some of the criteria, this is not an exhaustive list here on the slide, some of the criteria would be the type of the AI algorithm used. Is it an unsupervised algorithm? Is it a supervised algorithm? Reinforced learning, yes or no? Of course, the amount of learned knowledge is also a key factor. The output, type of target, is it variable? Is the output variable? Is it possible for the human to intervene into the output, to put a human original stamp onto the AI generated work or not? And is it in general predictable? Is the outcome predictable? By the human? Is it influenceable? Can you influence the outcome as a human or not? Or is it the machine in the end that decides? These are of course the crucial factors. So to give you an example, you may have heard about this example already because it's one of the most used examples when you come to AI generated works and copyright protection. That is the example of the next Rembrandt. The next Rembrandt is not a painting done by Rembrandt, but it is a painting that was generated with the help of AI after original Rembrandt paintings were fed into the AI. So a lot of Rembrandt portraits, in particular of white Caucasian males, were fed into the AI system, and then the AI painted this new Rembrandt. Well, but that's not the entire story. If really we were only at Rembrandt portraits of white Caucasian male persons fed into AI, and then here comes a new painting, this would not be copyright protected. But in this project, the next Rembrandt, that was not the case. Humans intervened. Humans intervened to get the right result, what they thought was the right result. So this next Rembrandt painting has, what I think, sufficient human input to be copyright protected because of the remaining human input. It's not a mere AI product. It is a mixed product of AI and human intervention. So that's probably sufficient to to generate copyright protection in the case. Another example would be music, AI music. you may have heard of the song Beautiful the World by Uncanny Valley. They won the 2020 AI Eurovision Song Contest by sampling koalas and kookaburras. It's an Australian group, an Australian project, you would rather have to say. And yeah, let's play the song. I've brought it with me. Flying in fear, but love keeps on coming. Flying, flying. Dreams to live on the wings of happiness. Dreams still, dreams still. Flying from this world that has gone apart. Flying, flying. Open up the heart, I ain't scared no more. Welcome home, welcome home. The world is beautiful, the world is welcome home, welcome home, welcome Yeah, I think we can stop here maybe. So this was Beautiful the World by Uncanny Valley. Also a song that was generated with the help of AI, but not entirely made by AI. It was also, as far as I've, as far as I've looked into the project, there was again sufficient human intervention to make this copyright protected. Yeah, if we were talking about music solely generated by AI, no copyright protection, of course, but I don't think that this is practically the case here. So, you know, as a result, you can maybe say, you know, in theory, mere AI generated works do not get copyright protection. But I think up to now, there are very few works that are mere AI generated. Most of the AI works we're talking about have still seen sufficient human input. If we don't get copyright protection, what about neighboring rights? These are neighboring rights for those who come from countries that don't know neighboring rights. Neighboring rights are usually rights that, you know, are neighbors to copyright, to genuine copyright protection, but the people that invest in creating works get investment protection. So it's an economic, you know, an economic justification. In particular, for example, you have in Germany, for example, but also in other EU countries, you have a neighboring right for photographs, which is unfortunately not harmonized on the EU level. In Germany, you would not get, you would get copyright protection for mere AI photos, but only if you photograph existing stuff, yeah, only if you photograph existing things. So no protection for photos of AI-made mere virtual objects. AI music may also be protected by a neighboring right because the EU harmonized neighboring right of the music producer is what I think a mere investment right, right to protect investment. And as you should also have an investment in if you produce AI music, there should be a neighboring right for AI music as well. AI film, same thing. It's also an EU harmonized neighboring right. And there should also be protection for AI films through this neighboring right, because this neighboring right protects the mere investment, which should be the case for AI generated films as well, because they require an investment. Interestingly, there is no neighboring right for AI created art. You only have copyright protection or no protection, yeah, in contrast to music or film or photos, for example. Well, more or less the same thing for AI texts. In particular, non-press texts have no neighboring right. You either have copyright protection or no protection. With press text, it's a little different, since the DSM directive, Article 15, which probably all of you will know, Article 15 DSM directive introduced a new neighboring right of the press publisher. And the question is if mere AI generated press texts will be covered by this neighboring right or not. I think probably not, because this neighboring right requires that the underlying texts are copyright protected. At least that would be my opinion, but this is open for discussion still. So if you look at the song I just played you, A Beautiful World by Uncanny Valley from Australia, that if it was a mere AI work, it could still be copyright protected. It could be protected by a neighboring right, at least for the music producer, for the record producer. Good news for the people that invest in AI music, even if they don't get genuine copyright protection. But what about the other fields of usual copyright protection, for example, art and texts? As I showed you, we don't have neighboring rights in this area. Of course, the question comes up, and that's maybe also a question for you in the audience. Do you think it is justified to introduce new neighboring rights for AI art or AI texts here, to cover them same as AI music or AI film or AI photos would be covered? Interesting question. Maybe we can discuss this after the talk. Let me just show you on the international level what are the developments. There's been a resolution of AIPPI, which is the International Association for the Protection of Intellectual Property, and where I have the chair to be the honor to be the chair of the Copyright Committee. So AIPPI has said no copyright protection without a sufficient human intervention. Yeah, as I've shown you, which is already the legal situation in Europe, for example, and I'm sure also in a lot of other countries around the world, because genuine copyright protection requires a sufficient original human intervention, which you need to see. And that's exactly also the position of AIPPI. Originality of the generated work resulting from the human intervention should be a condition for the protection of copyright, item 3 of the resolution. And then regarding related rights or neighboring rights, same thing, yeah, related rights and neighboring rights is the same thing. AI generated works should not be precluded from obtaining protection by existing related rights on the basis they are AI generated and should obtain that protection as long as they meet the required criteria for obtaining protection as a related right. And interestingly enough, AIPPI was not able to reach a common position whether you should introduce a new related right for the fields not covered yet by a related right, such as I showed you, art, for example, or texts. AI is as AI is still developing, it is too early to take a position on the question whether AI-generated works not covered by such existing protection as a related right should be eligible for exclusive right protection as a related right. So question left open by ARPPI whether we should introduce new related rights. WIPO and the US Copyright Office have also worked on the issue. At WIPO, there's a conversational intellectual property and artificial intelligence established in 2019. There was a third session in December 2020. The discussion continues. But at least there's consensus. I mean, at WIPO, you know, it's always very difficult with consensus, but at least that you should find a global answer to the question if you should have copyright protection for AI-generated works. And there's also a discussion at the US, in the US going on, with some interesting documents available on the website of the US Copyright Office. Yeah, so let me leave it here and maybe finish with the question, or with two questions. Do you agree that mere AI-generated works should not get copyright protection because no sufficient human intervention? And second question, do you think that we should have additional neighboring right, related right protection for those fields not yet covered as art or texts, for example? Thank you so much. That's all for now. And yeah, I welcome your questions now, or also any discussion interventions, of course. Thank you so much.
Wow, Jan Bernd, that was a very clear and instructive presentation. Thank you so much. I really liked it how you were able to combine, you know, starting with a table of contents, but then you made it into a joke. So you do both things at the same time, in a sense. Before we start off the discussion, I have a question already in the Q&A. I'll read it out to you. Regarding qualification of the next Rembrandt, might the qualification have been influenced by the fact that also the original Rembrandt pictures have not entirely been made by Rembrandt himself, but by his scholars? Rembrandt himself only giving some final touches to the painting. Upon this background, perhaps only a minimal human input might be deemed sufficient. Would we apply the same generous approach, for example, to a book, which is in general written entirely by the author?
Yeah, that's a very good question. Thank you. I don't think that the answer to the question if you know, the next Rembrandt as a new painting is also copyright protected really depends on whether Rembrandt painted the data feeded himself or whether his scholars painted it, because they are out of copyright protection anyway. Yeah. Rembrandt and his scholars, you know, they are dead for more than 70 years, so no question they are out of copyright protection. And even if they were still copyright protected, the data fed into the AI system in order to generate the AI work is not relevant to assess whether you get copyright protection for the generated product or not, because it's just data feeded. And for copyright protection, you always have to look at the product. If that includes sufficient original human input. You know, this was just the Rembrandt paintings. You cannot really find any, at least not that I would know. I'm not a Rembrandt expert, but I would not find anything that was copied, parts that were copied from original Rembrandt paintings, but really the system made an own painting, an own original painting. So if that can be traced back to a human, intervention in the AI system, you get copyright protection. Yeah.
Yeah. Okay. Thanks. Another question from the Q&A. How difficult is it to measure the amount of human intervention, and how much human intervention is enough then? Can you say something about that?
Yeah, of course. That is the question of all questions. And also, I must say, you get a real problem here in practical lawyer life. I mean, in theory, the question is probably easy to answer. You say the human input needs to be original, which is more or less individuality. Yeah, individuality. You know, it has to carry, as the CJU says, it has to carry the stamp of the personality.
Yeah.
So that's a criteria. But you know, the problem is, you see, for example, the next Rembrandt. And you cannot say from the painting whether it had any human input, whether everything was human input, or 0 or 50%, or whatever. So the problem is taking away copyright protection for 0 human input says you incentivize to lie. You incentivize people to lie about the human intervention. And say, well, this is 80% my human intervention, although it was only 0. Yeah, and that's a real issue, and that's something that I think will come up in the discussion of copyright protection of AI-generated works, how to keep people from lying and how to make people say the truth, how much human input they really put into this. And I don't know how you do that. Maybe you have to even, you put sanctions, civil law sanctions on it. Maybe you lose copyright protection if you don't say the truth, yeah, about your intervention, or you create a criminal sanction or so forth. There are different discussions going on here, but people at least in academia have already identified this issue.
Yeah. Wow. Thanks. I think we have to leave it at this for now and move on to the next speaker. So Ryan, your turn. And I think you have a totally different approach. And you're going to talk about patent protection for AI generated works. So please, the floor is yours.
Thank you very kindly for that. As I was asked to expand it slightly, I'm going to try and engage a bit with what Jan said, which I really enjoyed. I don't have a table of or an outline to start with. I am sometimes British, but as I'm here in America, I don't have a joke either. But they're generally not very good unless you're Jan. So I think we could just kind of get into things. AI is doing some really cool stuff these days. Although when you say AI makes a painting or invents something, that is indeed a whole set of issues, which I'm going to talk about in a moment. But to pick one example, a team at Google published this article in the journal Nature in June of this year, and it describes development of an AI that can generate a chip floor plan. And that is the design essentially of a microchip, which affects its performance. And this article claims that an AI, having been trained to do this, can now do it in 6 hours, as opposed to teams of people which take months to do it, and that the AI's chip design substantially outperformed the designs done by people in all key respects. Chip floor plans are something generally protected by intellectual property. In the US, we have a sui generis protection regime for something like that, because it's essentially an aesthetic design that has a functional outcome, and it was felt not to fit neatly within design law or patent law. But this raises interesting questions around protection for things like this and the impact socially of AI doing things like this. Jan mentioned a bit too the WIPO work that's going on. This was a case study presented at the WIPO First Conversation on AI and IP by Siemens. And the car on the left is a traditional car suspension, and the car on the right is one that came out of an AI. And Siemens wanted to file for a patent on the AI-generated car suspension and decided they were unable to because all of the engineers involved in the project refused to list themselves as inventors. Their position was essentially that they had an AI that helped design industrial components. They gave it publicly available information. They told it what they were looking for, none of that which was inventive. It spit out a design they all decided was valuable, but really none of them felt that they had been inventors on this. And as a result, Siemens was unable to file for a patent, or thought it was unable to file for a patent, and says that this sort of thing happens now at Siemens and not just in this one particular case. This, in any case, of all the issues associated with AI making patentable sorts of things, is really the key commercial issue. You know, can you get a patent on it? Or at least this is the issue of most concern to the businesses that own most patents around the world anyway. Now, as Jan said, you know, can someone be an inventor on something like that is a complicated question. And to give the lawyer's answer, it depends. There's a lot of ways that someone can be an inventor. So, for example, sometimes finding a problem to solve can make you an inventor if a problem is not well understood. Of course, it's usually the case that we do know what we're looking to find. We know we want a better vaccine to COVID-19, or we want a better car suspension. So that doesn't normally do it. Training an AI or programming an AI to invent something might make someone an inventor, particularly if you were training or developing the AI to solve a specific problem, like generate a better microchip design. But there's also going to be times when there's problems with that. For one, some AI systems are developed by hundreds or thousands of people spread over time and space, which is one challenge. You know, the other is sometimes the people using the AI are different than the ones who are programming it, and the people programming it may not even know exactly what it's being used to do. So let's say that this Google AI is licensed to Intel, which uses it to generate a bunch of new microchip designs. Well, under at least US and UK patent law, no one at Google would be an inventor on something like that, because if they didn't know the actual invention coming out, they wouldn't have, you know, conceived of the claims of that invention. Sometimes recognizing inventive subject matter can make someone an inventor. And, you know, particularly if you're the first person to notice that penicillin seems to be inhibiting bacterial growth. But if an AI spits out something like, here's a car suspension that does what you're looking for, or here's a new COVID vaccine that with 99.99% certainty is likely to be more effective, here's how you test that with clinical trials, and here's all the data you need to support a patent application, it's not clear that anyone's exhibited any inventive skill with respect to that application. And as we are going through even defining these terms like AI generated inventions, you know, and defining them has proven to be very controversial. Perhaps not surprising, given that people still can't define artificial intelligence, even though it's now a subject of new AI regulations, which we're going to hear about in the EU. Not that they don't have their own definition for it, but you know, there's a lot of people talking past each other in this space. To me, at least one of the key issues for an AI generated work is an AI output made under circumstances in which there isn't someone who traditionally qualifies as an inventor. So the importance of this issue has not been lost on people. You know, AI has been making new creative works for a long time, for decades, but historically they've been pretty terrible. What's gotten more interesting about that is they are no longer so terrible, and they are almost at a level where they may have commercial value, where you're making music that people almost want to listen to and writing articles people almost want to read or sometimes can't tell were written by a machine. We're probably a little behind that in terms of AI making patentable stuff, but it is a lot harder to come up with something patentable than it is to make a terrible new song. The USPTO issued a request for comments on AI and IP generally and AI patents, which was not terribly well defined back in 2019. It largely found that there wasn't much to do in this space. A year later, the UK IPO issued a similar consultation and found, differently than the US PTO, there do seem to be some unresolved commercial issues, particularly subsistence of patents in AI generated works, or whether that sort of process can result in something patentable. The US just published a important report by the National Security Commission on Artificial Intelligence. This was a commission established to look at AI industrial policy in the United States. And its high-level finding was essentially that the US wasn't doing too well compared to China and needed to restructure its AI industrial policy. And of the key issues that form the AI industrial policy and international competitiveness, AI and IP was one, and issues like inventorship by AI were also critical to this. And then, as we heard, WIPO has been working on this, less to provide solutions to some of these problems than really to set out the key issues that countries should be discussing. You know, coming to international consensus on something is a mighty slow process, but they are encouraging stakeholder dialogue. Different countries have different opinions on this sort of thing. Different countries haven't even figured out their opinions on this sort of thing. And there are a whole lot of interesting issues with AI and IP, not just AI making things that might get copyright or patent protection, but AI functionally infringing, and liability for acts by AI, and how AI will be challenging human-centric standards. Moving from copyright to patents, right? This phenomenon in which you have an AI having patentable output without a traditional human inventor raises at least a few interesting questions. The most important of which, I think, as discussed, is, well, can that sort of thing get a patent? And if it can get a patent, who or what would be the inventor? Does a patent need an inventor? Does an inventor have to be human? Jan mentioned, an author's own, it's early here, right? But if you look at CJEU case law, one rather does come away with the assumption that an author is a person, but that is also an assumption, and there hasn't been a case on this yet. And don't get me wrong, in continental Europe, that'll probably stand up, but not all jurisdictions feel quite the same way about this. Some laws do discuss inventors in more or less human-centric sorts of terms, and there is case law in a number of jurisdictions that inventors are natural persons. But also, as far as I'm aware, every case that has ever looked at that has asked about it in the context of, can an inventor be something like a company or a country? And that is an issue that has been on the minds of people for decades. It would be easier if IBM could be its own inventor and wouldn't have to track down inventors and assignment obligations for everything it comes up with. But there's a principled reason not to let a company be an inventor, because companies literally act through human agents. And if a company didn't have to list an inventor, people would lose out on being acknowledged for the work that they were doing. And AI does not have to work through human agents. In fact, in these cases, it is not acting through human agents. And so there is no person who is losing out on inventorship credit by potentially having an AI listed as an inventor or having no inventor listed. And then if you can get a patent on something like this, how would entitlement work and who would own it? Jan mentioned the continental European approach to AI generated works and copyright. The UK has explicitly protected AI generated works with copyright protection since 1988. There haven't been a lot of cases on it, but also copyright isn't registered in the United Kingdom, and so it would have to come up in litigation. The US has, through the Copyright Office, so not statutorily, just in an administrative office policy, been rejecting AI generated work since at least 1973 on the theory that copyright is something that comes from the mind of an author, and machines and monkeys don't have minds capable of generating copyrightable sorts of works. But there's a lot more, or there was a lot more law on whether or not you could protect an AI generated work with copyright than there was with patents. I've been working in the space academically for 8 years or so, and would go out talking about this, and people would find it vaguely interesting. And a few years later, companies would come up and say, well, what should we be doing about this? And there were a lot of assumptions about whether or not this sort of thing could be protected at all. So this was one reason why I and a group of patent attorneys filed a series of test cases for 2 AI-generated inventions without a traditional human inventor. We filed these first in the UK and in Europe at the EPO, because in those jurisdictions, you don't have to disclose inventorship for 18 months. The patents underwent substantive examination and were found to be new, non-obvious, and useful, or novel, having an inventive step, and industrially applicable. I'm confusing the standards, but you get the gist of it. At the point of preliminary examination, and then we corrected the inventorship and said, actually, this was made by an artificial intelligence, and it was promptly denied on those bases, not rejected, but denied on a formalities basis that we had not named an appropriate inventor. We subsequently filed the jurisdiction in 15 more places. It has been rejected from denied by the US, Germany, Australia, and I think that's it. I'll come back to that too. Again, on the basis that we did not comply with the formality requiring someone to be an inventor. Now, not all countries have these same formality rules. In Israel, for example, you don't have to name an inventor on a patent. An inventor, if not named, is only named if the inventor files basically a request with the patent office saying they have been left off the patent and they want to be on it. Cyprus and Monaco reported to the European Patent Office that they did not require inventors to be natural persons. But in any case, we filed this patent. It was accepted by the receiving division in WIPO. I understand someone played this earlier, and I would have been listening if it hadn't been 1 something in the morning. Yet more reason it would have been nice to be in Barcelona for this. Just you leaving aside that Barcelona is nice to be in generally. And here, as you see, the applicant, Dr. Thaler, is the person who owns the AI. The inventor is listed as Dabis. And you know, people had talked about this sort of thing academically for a number of years and basically said, well, why would an AI generated invention need a patent? Because machines don't care about patents. And that is certainly true. But the people who make, use, and develop machines care about patents. And those are the people whose behavior we're really trying to incentivize here, right? So this encourages investment in artificial intelligence, and it encourages people to use artificial intelligence to generate socially valuable innovation. If you didn't allow protection on inventions like this, then in 5 or 10 years, when we have COVID-23 and Pfizer and Johnson & Johnson go to AI to help sequence the new pathogen and find an antibody to treat it, if you don't have a person in the right place in that equation, you may not be able to get protection for that sort of output, and thus companies are less likely to use AI to do that sort of thing. So in July of this year, we received our first patent. We received a patent in South Africa with the patent owned by the AI's owner and the AI listed as the inventor. South Africa is not a substantive examining jurisdiction, so they do not look at novelty, inventive step, and usefulness in issuing patents, but these patents had already been evaluated for that by the UK and EPO. And South Africa does do formalities examinations, and in every jurisdiction where the application has been denied, it has been denied on a formalities basis. 3 days later, we had a reasoned decision by Justice Beach in the Federal Court of Australia, holding essentially along the same lines, that an AI could qualify as an inventor under the Australian Patent Act, which is very similar to the UK Patent Act. That in this particular case, Dr. Thaler seemed to have the clearest basis for entitlement, and that there is no reason why a patent on an AI-generated invention shouldn't be possible. You know, on the entitlement front, this also varies by jurisdiction. In the United Kingdom, for example, one can be entitled to a patent by being an inventor, or more commonly by employing an inventor, but also through any rule of law. And while this issue hasn't come up in a case yet, our argument was essentially that common law rules of property ownership apply here in the case of an AI-generated invention. If you own a 3D printer that prints something, you own the output of that 3D printer. If you own an AI that generates patentable output, you should own that as well. That's reflected in rules like accession or first possession of property. And so we argued those in Australia successfully. Not to give the sense that we're having these sorts of outcomes across the board. The case was dismissed by a district court judge in the US in the Eastern District of Virginia a few weeks ago, who wasn't as receptive to some of these same arguments. This case is being appealed to the Federal Circuit. We had the case recently rejected by the UK Court of Appeals about 2 weeks ago. The court in that, though split 2-1, Lord Justice Burse sided with us and agreed that although an AI could not be legally an inventor, it could invent, and there should be no prohibition on patenting this sort of thing. And the patent office was under no requirement to list the AI as the inventor, but did not have a grounds for rejecting the application. The other two justices disagreed, and that case is in the process of being appealed, which is a discretionary process to the Supreme Court. We also have an appeal pending before the European Patent Office Legal Board of Appeal. The hearing on that is December. In preliminary comments made by the board, they suggested that one possible solution to this was where you don't have a traditional human inventor, that you simply don't list any entity as an inventor. And so we will see how that resolves there as well. And the case is bogged down in German appellate court, but most of the proceedings are in German and I have a little hard time following them. But did recently get some interesting comments from the president of the German patent office, which I'm going to have to send you on at some point. So that's about where the cases are. And, you know, I think the cases have been successful in both getting some more clarity around these issues and starting a stakeholder dialogue around these issues, which was largely why we were doing them in the first place. And it has also revealed a split of how jurisdictions think they're going to deal with this sort of thing. Other jurisdictions have announced that they are looking at political solutions to this. A parliamentary consultation in India recently recommended that the law be amended to explicitly allow protection of AI-generated inventions. India, like the UK, already explicitly provides for protection for AI-generated works for copyright. And the president of South Korea recently announced that these sorts of works should have protection. So I think that things are changing very quickly, even in a short amount of time. And, you know, just to give a kind of parting thought on this, you know, AI making new, useful, inventive stuff is very cool today. I think, though, in 10 or 20 years, it may be profoundly socially disruptive if computers continue to improve at the pace they're improving now. You know, AI may never be able to compete with something like Katy Perry, but it probably could make better music than, you know, average or mediocre musicians. And that's going to have a really big impact on the market for music. You know, similarly, when AI starts generating a substantial amount of socially valuable innovation, that's really going to change the social landscape and the financial landscape for research and development in a lot of areas, and probably some areas more than others. And as I have a background as a life science patent attorney, you know, I see a lot of areas where AI could do heavy lifting in things like repurposing drugs and finding new drug candidates and testing new drug candidates, and really speeding up and improving the whole life sciences R&D process. And at some point, when AI gets to do this on a widespread scale, you know, it may even impact the standards we use to evaluate creative human behavior, because it may no longer be non-obvious to come up with a new antibody to a new pathogen when AIs that are widely available to pharmaceutical companies can do that with trivial ease, you know, the same way Google now says they have this AI that generates new chip floor plans. And as a final parting thought, you know, I wrote about this recently in a book out last year, The Reasonable Robot, Artificial Intelligence and the Law, where I argued that somewhat counterintuitively, the law should really not discriminate between behavior by a person and behavior by an AI, and that this results in all sorts of negative and unintended consequences. And in this context, for example, by having two separate sorts of protection regimes, one for inventions made by people and one for inventions made by AI, what you're really doing is saying to the inventive economy, we want you to disfavor this particular route of inventing, even if it ends up being a much better route of inventing for reasons that I think are not good, because depending on the jurisdiction you're coming from, what we really want out of a patent system is more socially valuable innovation. And I think we will get that by encouraging the use of AI and R&D. And I'll stop there and see if we have any questions. We don't. Hopefully I wasn't on mute.
Yeah, give us some time, Ryan, to process all this. Well, thank you for a very thought-provoking and inspiring presentation. There is indeed so far no questions in the Q&A. Maybe we just need some time to think up questions.
We've got one question here. So
there it is. Yeah.
AI systems have no personality, therefore cannot be under the law, but the owners, yes.
Yeah.
I assume that refers to legal personality, to which, yes, a lot of reporting on this case was about whether an AI could get a patent. And I blame reporters who like that as a headline. It is a little disappointing when I see patent lawyers echo those sorts of sentiments without having reviewed any of the files in the case, but it happens. So it's never been anyone's contention that an AI should own a patent. An AI couldn't own a patent because it doesn't have legal personality, but you could amend the law so AI has legal personality, but it just wouldn't make a lot of sense. An AI wouldn't care about getting a patent, couldn't, effectively commercialize a patent. Really every outcome that we want here is achieved by giving the AI's owner entitlement to the output of any AI, right? So I don't think that we should be granting legal personality to a self-driving car, a 3D printer, or Davis, but, one could do it. It just wouldn't make a lot of sense.
Yeah, but the point would be to incentivize investments in AI, right? So that beautiful things are invented that contribute to the common good, right?
Yes, right. Investment and use of AI, but yeah. Exactly.
Yeah.
I mean, ultimately, it is people that we are incentivizing by granting patents on AI-generated works.
Exactly, because it makes no sense to incentivize the AI itself, because by itself, it has no purpose or no way to be incentivized. Jan, you put your camera on. Does that mean that you have a question?
Yeah, maybe a short question from the copyright perspective to Ryan. Thank you for the excellent presentation. Just one question, because you also mentioned that maybe even machines should get copyright protection, genuine copyright protection. Isn't there an issue with the very long term of copyright protection in these cases? Because well, the human, the 70 years after the death of the author, which is the term of protection, is of course calculated because it should be 2 generations after the natural person author. If you start to protect investment through copyright in AI systems, probably 70 years after the death is, well, you cannot calculate it anyway. And wouldn't it be more appropriate to have a shorter term of protection for these kinds of, if you award protection, but shouldn't it be very much shorter?
Sure. Well, and to be clear, when I said the proper copyright, again, the copyright would be owned by people, but for works made by AI. Now, a couple of responses to that. So the UK, which explicitly provides for this protection by statute, does have an unusual provision, which is that where you lack a traditional human author, the producer of the work, as in a film producer, is legally deemed to be the author. And it does get a shortened period of statutory protection, which is 50 years from the date of creation. Obviously difficult to base it on the death of an AI, which, never dies, but also really never lives. I still don't think that I'm a fan, though, of a different system of protection. And again, the reason is, I think that well, and jurisdictions and social values differ here, whether copyright is primarily something that helps struggling artists or something that primarily helps companies like Marvel and large investments. I think in the US, we have a much less romantic conception of the purpose of copyright law than they do in continental Europe. But again, I think it creates these two different markets and two different incentives. To me, that's really an argument saying, well, isn't 70 years plus somebody's life probably longer than we need for just about anything to start with? And so isn't that really the problem? Not that we would be giving an AI generated work too much copyright, but we're pretty much stuck with 70 years plus life. So, I'd be willing to take 50 for an AI.
Yeah, okay, well, thanks, thank you. Moving on, I think the time is now for Alessandro Mantelero to give his presentation. The floor is yours.
Thank you for the floor. It's a pleasure to be here, and I want to say that it's a pity not to be in Barcelona, but I think after these two presentations that are very focused on the impact of AI on the things, if you want, on the artistic and industrial creation, I think that can move from a different kind of perspective with regard to the impact of AI on society. And this perspective is more related with regard to the humans rather than things, and the impact that the adoption of AI solution, AI system may have on individuals and society. As you know, this is main issue at regulatory level. There are several initiatives. Probably the most relevant at the moment is the proposal from the European Commission on the future artificial intelligence regulation, also known as AI Act. This is still a proposal recently introduced by the Commission. There is the ongoing discussion of the text, but is an important starting point. And in this sense, also compared with the copyright issues that were well known also at EU level, I think it's a significant the fact that the European Union decided to start from the risk for individuals and society. And we'll see that, on the other hand, this approach is not an approach only focused on individual rights and freedom, but is also an approach that look at the market and the impact on AI regulation on the market. So starting the discussion, I think that we have to consider that the approach adopted by EU, and this is known as a risk-based approach. A risk-based approach means that with regard to the AI, the main concern is about the risk that new AI application might create in society. And in this sense, when we want to deal with the risk of a new technology, we have different kinds of strategies available. One strategy that was adopted at the beginning of this debate was focusing on the ethical framework, new risk, new concern, and the need for guidance, the need for ethical framework. This was not only a EU approach, mainly from the European Data Protection Supervisor at the beginning, but was also an approach adopted by many companies that create ethical boards, ethical advisors, etc. This was the first approach. Then we moved from this situation of uncertainty that in many cases generate this interest for an ethical framework, we moved to a more concrete regulation based on the law. And when you want to address a new technology, considering the legal framework and considering the issues about the potential negative impact of this technology on society, you have basically two ways to address the problem. The first one is based on the focus on the consequences of the use of this technology. So focusing on the remedies, compensation or other forms of remedies, punitive damages, depends by the legal framework and legal culture. So the idea is to have a sort of ex post approach. So we use a technology, when something wrong happens, we have some solution. This is an important instrument historically in order to deal with innovation and technology, because it's a careful manner to put on the shoulder of who used the device or who created the device the burden of proof and the burden of liability with regard to what happens as a consequence of the use of this technology. And historically, also in the Industrial Revolution, we adopted this strategy, and we decided to have different kind of liability regime, strict liability, fault liability, and many gray zone in the middle, in order to decide how to impact on technology development and the use of technology. But this approach, that is quite important, has some limitation with regard to the use of AI. Which kind of limitation? First of all, AI is a quite complicated framework. It means that compared with the traditional approach that we have, for instance, in product liability, traditional products are created by manufacturers that have a sort of general overview about their creation, and then are used by the end user that usually have not a lot of options in terms of using this device and tools. So the system is quite rigid, if you want, and easy to be designed and structured. But if you consider AI, the situation is a bit more complicated, because we have different actors. We have those who create the device, the hardware, the software, the sensor, and then this device with AI embedded are able to learn, in many cases, through the interaction with the external world, if you want, with the user. So it's not so clear the role of the different actors. Is not so clear if the final user is a mere user, or through the learning capacity of the machine have an impact on the way in which the machine acts or reacts, and so on the potential liability related to this kind of action. On the other hand, we have the problem of obscurity. Many cases, AI systems are not so transparent in terms of their functioning. Sometimes this is critical also in terms of explainability, because are not explainable per se, is a technical barrier. And for this reason, there is an increasing interest in AI design about explainable AI and related tools. Moreover, in many cases, we have a lack of awareness about the impact or the harms created by AI. If there is a discrimination for some categories, in many cases, we are not aware to be discriminated, because this discrimination can be hidden in the functioning of the system. We need investigation, we need tests to check if something wrong happened in the design and the functioning of the AI. We have some famous case like the Compass case, but many others also with regard to big companies, such as the historical bias in Amazon recruiting system, etc. But in many cases, we became aware about that after a certain time. The system have been used, so it's not so evident. It's not like in many other contexts in which the impact is immediate. And the third point is the environment, the industrial environment or the business environment in which we create AI. In many cases, AI is, of course, there are few big players in the AI, but there are many small startups, small players that develop specific solutions that are used in a municipality, in a company, in some specific context. These are small companies in many cases that are not so aware about the consequence of AI in terms of impact on individual rights and freedoms or on society. They are very focused on obtaining the best gain in commercializing their product or be bought by big companies. So there is a lack of awareness and also lack of activity of liability in this case, because it's not so easy to have a deep pocket in that case, and so the deterrence is not so strong. And the last point, the systems are used in contexts in which, in many cases, the final user individuals have not a lot of voice. If you consider the system adopted by governments, adopted by municipalities, or by big companies that have an important market share, this make difficult for individuals to react, to know, to have an alternative solution. So for this reason, imagine to deal with AI only focusing on reaction, on remedies, on the opportunity for individuals to make a legal action in order to ask for compensation for the damage, etc., is not so effective. For this reason, the focus on AI debate with regard to its regulation is mainly centered on sort of ex-ante approach. It means to prevent the risk, to prevent the negative impact of AI. And this is not so new at the end, because if you look also in medical sector, in drug production, or also in personal data, the idea is that you have to prevent the risk through system of risk assessment and check, and use liability as the last opportunity, as a sort of the closing rules of the system. When you are not, have not the chance to prevent this risk and risk happen, then we have the liability rules. In this sense, looking at AI, there are two main areas in which we can imagine to counter the potential risk related to the use of AI. The first one is the traditional field of product safety. If you consider Industry 4.0, if you consider self-driving cars, etc., we have a context in which we have machines that are better than before because they are supported with the AI system. But at the end, the main concern in this environment is about safety, about the harm that this device or system can create for human beings, etc. But there is another field that is probably more important and also discussed over the last few years, and is the impact of AI solution not on human beings in terms of the body of the human beings, but in terms of the rights and the freedoms of human beings. So the impact on individual rights and freedoms, because when you use AI to manage social technical systems such as smart cities, when you use AI to boost interaction between humans and machine, for instance, in companion robots for kids or for elder people, or we use AI for making decision with regard benefits for citizens, for students in order to have access to the university, for instance, or many other kinds of AI supported decision, or in some cases fully automatized by AI. If you consider this scenario, of course, the risk in terms of impact on individual rights and freedoms is much more relevant compared with the traditional product safety risk. And the last point that is important to have in mind in order to deal with this new risk generated by the AI is that, as also mentioned by my colleagues in the previous presentation, although from the angle of their creativity, AI per se, of course, can create something or can decide something, but this system is always generated by humans, are humans that put in the AI the values, that put in the AI the main elements that are used by the AI to make decision. So in this sense, it's not the AI system that creates their own values, but the AI system elaborates and put in practice the input received by humans and by the data that humans put in the system, etc. So this is important because if we consider that AI systems are value-based system, the focus should be on which kind of value we have to put into this system. And for this reason, one of the most important blocks of the European Union proposal on AI regulation is about risk. Of course, there are other aspects concerning, for instance, the supervisory authorities, concerning some specific rights in terms of transparency, etc. But the risk is the core aspect of this new proposal. And if we consider risk in general, risk assessment, in AI, such as in many other fields, we always have the same methodology approach in dealing with the risk. So there are some common criteria that we have to adopt: planning and scoping the analysis of the risk, collecting the data, carry out the analysis, and assessing the level of the risk to mitigate the potential negative outcome. And to do that, usually we need experts, because the risk, one is a risk that impacts on society, on individuals. It's not something that can be measured like the risk in a car accident. This cannot be measured on the basis on the hard science laws, but it's something that should be assessed considering the complexity of the social system and the social technical system. And for this reason, the risk management in AI, when is related to the impacts on society and individuals, is mainly based on the role of the expert that can provide their feedback in terms of assessing and considering the potential negative outcome of AI. And the system also can benefit from the participation of the target groups, the potentially target group, in order to have feedback to better understand the risk. This is not something new. It's a common practice in many fields in which we carry out the impact assessment with regard to the human rights or also the social impact assessment. In this regard, the Artificial Intelligence Act proposed by the Commission adopted a specific approach in dealing with this general framework of the risk assessment. In what sense? First of all, the decision of the Commission was to limit to a certain extent the range of the intervention of this new piece of law, in the sense that it's very focused on the banned application. There was a lot of debate about facial recognition in public space, etc. And then for the rest, the proposal almost only cover the high-risk cases. So it's not about AI in general, but it's mainly about the high-risk application of AI. And this is a clear decision in terms of industrial strategy. So the idea that only when there is a high risk, we set some rules. For the rest, if the risk is not high, doesn't mean that it's low, but it can be also medium risk. This is not covered by the law. Of course, there's a trade-off between protecting individuals and society and not creating extra burden for the developers of AI and AI manufacturers. And such in the past, in other fields of industrial production, the legislator have to find a sort of balance of these competing interests. And here, the European Union decided that the balance is focused on high risk only, or mainly. There are a few provision also about no high risk application, but are very, very limited provision. So first of all, the risk assessment is limited to high risk or very high risk, but in that case, the applications are banned. Second, there is a sort of overlapping and mix between the impact on individual rights and freedom, and the impact on safety and security. That is not so good in terms of clear description of the requirement. Third point, the Commission in its document, in its proposal, adopts a sort of top-down approach based not on the traditional human rights impact assessment, but on technology assessment. It means that there is a list in Annex 3 of some technology that are considered as high-risk technology. It's a technology assessment because it's based on assessment of the technology per se, not with regard to the specific application, the specific case of that technology. And with regard to this list, there are some concern because this is a closed list with all the problem of updating closed list. And there are some categories in this high risk application that are broad, other ones that are very narrow. So it's not at the moment, at this stage of the proposal, the feeling is that there is something that is not in the list, but should be in the list. And there is something that is in the list, but should not be in the list. And the last point is that a closed list may be a problem compared with the variability and cross-cutting nature of AI. So if we look to the impact assessment with regard to AI, the impact on individual rights and freedom, so you can say human rights impact assessment. The Human Rights Impact Assessment is used in the Artificial Intelligence Act proposal, but as a tool for risk mitigation rather than risk assessment. What it means that if the high risk situation are already set by the law, the assessment is not to check if the risk is high, medium, or low, but you already know that that case is a case of high risk. And in that case, the assessment is also only a tool to identify where the risk is in the system and how to mitigate this risk. So it's a bit different from other approaches that are focused on the human rights impact assessment as a system for risk management in a general sense, so assessing and mitigating. Here, the assessment is done by the technology assessment carried out by the Commission. And the big problem in this system is that there is not a model for the human rights impact assessment. And this is a critical from two perspectives. First of all, the list of the case of high risk in Annex 3 is something that is provided, but there is no any evidence. There is no any risk assessment that show that these are high risk. It's more a political assessment. A second, if you are in the case in which the future regulation is applied, so you are in a case of high risk application, you have to mitigate the risk. So you have to carry out a risk impact assessment to check which kind of rights are impacted and to define a strategy of mitigation. But for that, you need, again, a tool. So the quite strange situation is that we are creating a system based on high risk without having a tool that can put in practice this high risk. And this is something that we have to work on in the future months or maybe years, it depends. And this is very important because this system is based on thresholds, high risk, no high risk. So it means that you have to create a system to assess the level of risk and to define the strategy to mitigate that. And we did a certain exercise in this sense, and we have created a model that try to fill this gap in the existing regulatory scenario and try to provide us potential solution in terms of human rights impact assessment for AI. That is something different from the traditional human rights impact assessment. But if you want during the Q&A, we can further elaborate on it. And so the idea is that there are two main elements to be considered: the likelihood and the severity of the impact. And the likelihood should be divided in two main areas: the probability of adverse consequence, that is quite traditional idea of likelihood, but it's also important the exposure, so how many people are potentially affected. On the other hand, severity is about the gravity of prejudice but also the effort that you have to put in practice in order to counter the potential prejudice or to reverse its effects. And in order to give you only a few idea about that, this is the approach probability, the description of probability. For instance, risk of prejudice is improbable or high improbable, so the risk is low. Exposure, some identify the population are potential affected, so the risk is medium. So the idea is to use threshold, low, medium, high, very high, not use a mathematical model, but use cardinal case. Cardinal case, it means that the expert evaluate the potential level of risk and use a matrix like this one on the right. That is not a mathematical model based on the sum of the factors, but is an evaluation scheme that, based on expert evaluation, consider that, for instance, when the probability is 2, so it means is medium, and the exposure is low, the general impact is low, and so it's green. This is a quite common approach that used in risk assessment and in the multi-criteria analysis. And this is a typical multi-criteria problem. And the same is for prejudice and effort. You can create a matrix. Based on this matrix, you can assess the severity and you can assess the likelihood. And then you have a final table in which you put together severity and likelihood, and you can check if your application have an high or medium or very high impact on unspecific rights. Of course, you have to do that for all the potential impacted rights. And the result is that you can create a sort of radial graph like this one, in which is evident the different impacted on the rights. And this is useful for your strategy of mitigation, because if you realize that this impact is very high, for instance, on data protection, like in this graph, you have to start from data protection in order to mitigate the potential impact. And for instance, if the physical integrity is quite low, impact is not so relevant in terms of strategy of mitigation. This solution, of course, requires a circular process, because you assess, you mitigate, and reassess in order to check that the mitigation measure works well. And it's much better if this is done also with the cooperation on the potential impacted stakeholders of targets. This is better described in this article that is open access, and is a contribution to solve the problem of the Artificial Intelligence Act that relies on a risk-based approach that focus on high risk and high risk mitigation, but unfortunately does not provide any solution in terms of concrete and operational mitigation and analysis of the risk. And I think that also in this context, in the context of this conference that I think is also attended by many practitioners and experts, it's very important to focus not only on the legal regimes, but also on the implementation of the legal regimes. That is the most challenging aspect for those who have to deal with the issues related to AI. Thank you.
Wow. Thank you, Alessandro. That was a very clear, instructive, and inspiring presentation, and especially the graph and your proposals for assessing the risk. And fantastic. I really have to look into that a lot more. There is one question in the Q&A that I would like to pass on to you by Ulysses Cortes. Do you believe that AI-based solutions have more negative impact than other technologies? Maybe the focus on AI is distracting our attention from other problems.
I agree with the message between the lines in the Ulysses comments and question. I think that the issues related to the fact that when we talk about AI, we consider AI as something that is uniform, but AI is not uniform. There are many forms of use of AI. There are forms that are not existing, like a general AI, and probably will not exist in the future. It's a matter of discussion. And there are very stupid application of AI, very basic application of AI, and there are very challenging application of AI. So in terms of AI, I think that the impact of AI is not higher than the impact of cars. You know that many people are killed by cars every year, and this is an historical problem that we deal with. But like of the cars, and there was an important famous book of Calabresi on that, like in the cars, we have to deal with the risk that AI poses for society. So I think AI-based solutions are not more negative, but there are some AI solutions that raise new issues that may be more negative than the existing than the way in which we carry out the same things in the existing world. To give you an example, professor and the educational system select students in the system. This is done by person. This is done on person evaluation. If we will replace the person evaluation with AI, this may have an impact that is much more relevant than the traditional mistake of a professor in terms of transparency, in terms of serial effects, because an element that we often miss in this discussion, that we use artificial intelligence, assuming that the intelligence of a machine is the same of the intelligence of humans, but they are different. And one of the main distinction is that they act in a serial manner. So if there is something wrong, a bias or an error in the system, this error is for the entire series. So this is also in the discussion where we talk about the impact of AI in the judicial system. Mm-hmm. Of course, you know from the realistic approach in the studies in the 70s that a judge can have a bad decision because that morning they have a bad.
Yeah, indeed.
But the solution to replace the judge with AI means that if there is a bias in the AI, it's not the first case decided by the judge, exactly, but all the cases that are wrongly decided. So in this sense, I think that if you consider this element, yes, the impact of the decision to replace human being with AI in some contexts might be higher in terms of risk compared with the traditional way in which we make the same things. So in this sense, there may be a higher risk, but it depends by the context. For instance, in image recognition, AI is better than us. So it depends.
It depends. It depends. That is always the conclusion, right? Okay, we are 3 minutes past 1 already, so time to wrap up. I want to thank our panelists for their valuable contribution, the audience for being here, for your attention and your questions, and the organization for making all of this possible. And on behalf of the organization, I have an announcement to make. We disconnect after this until 2 p.m. Central European time again, with the Blockchain and European Union Initiatives panel. So for now, have a nice day or night, whatever. Enjoy your lunch or your breakfast or your dinner or whatever. And I hope at some point to see all of you live, either in Barcelona or in Helsinki or wherever on the planet. Thank you and bye-bye.
Thank you. Bye-bye.
Bye-bye.